The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. Our court has enjoyed taking cases on the road, and this is no exception. So we appreciate being in Iowa City and the opportunity to have a case before us. And thank you for both counsel for agreeing to move from what we would normally be in Des Moines to Iowa City. So it appears both parties are ready. We're here today for the case of State of Iowa versus Jaheim Cyrus. Mr. Irwin, are you ready to proceed? You may begin.
Thank you, Your Honor. May it please the court, counsel. The district court and the Court of Appeals concluded that a reasonable person in Mr. Cyrus's position would have felt free to disregard Officer Morgan and leave. Respectfully, and as a result of that conclusion, they also concluded that no seizure occurred in this case. And respectfully, that conclusion is incorrect. Mr. Cyrus respectfully requests that that his conviction be vacated and all evidence stemming from that seizure be ordered suppressed, and the case remanded to the district court for further proceedings. At around 9:00 p.m., Des Moines Police Department received a call from a citizen reporting that she had observed a car turn around in a driveway and then park at the curb on the street near her house. No illegal activity whatsoever was reported. Officer Morgan was sent to investigate that circumstance, and when he arrived, he parked in the middle of both an intersection and the street. And it is a dead-end street that Mr. Cyrus is facing. He turned on flashing overhead lights. They were rear-facing. It was unclear whether they were amber or red and blue in color, but he did turn on his overhead lights. He aimed his spotlight directly at Mr. Cyrus. He exited his vehicle quickly and testified he did that so Cyrus wouldn't leave. And he told Cyrus to stay in the car when Mr. Cyrus opened.
Isn't that disputed?
It is disputed, Your Honor, yes.
And if we're supposed to give great weight to the district court's findings of credibility, why should we change that normal procedure and say otherwise? He came right out and said, I did not find Mr. Cyrus credible on that issue.
He did. That's correct, Your Honor. And there is deference given to the district court's credibility findings, but it's not total deference. And the reason that finding was incorrect, first, I note that the district court said it wasn't convinced that Officer Morgan said anything at all. That's contradicted by all evidence. Even Officer Morgan admitted he said something to Mr. Cyrus. He just said he couldn't recall if he told him to stay in the car or not. I won't belabor the point. I maintain that order is audible in the video exhibit. If it's listened too loud, he says it immediately after he says 303 into his radio. But even if the court disagrees with that, it's important to keep in mind that the burden was on Mr. Cyrus to establish by preponderance of the evidence that a seizure occurred. And so we should be looking at this through that lens. Officer Morgan admitted he said something, he just couldn't recall what. He also admitted that immediately after he said whatever he said, that was when Mr. Cyrus put his foot back in the car.
So you see him kind of as if he's stepping out. And Cyrus testified, he asked the officer, can I get out or something? So is the video consistent with a command to get back in the car?
It is, Your Honor, absolutely. You can see Mr. Cyrus react to that order and put his foot back in the car and remain in the car.
Is that enough, though, to establish a seizure? Tone of voice could be, stay in your car.
I believe it is. I understand it's always an evaluation of the totality of the circumstances, and things like tone of voice matter. But a police officer saying, and especially after being asked, may I exit? And the response from the police officer is no, stay in the car. That, in my opinion, is enough in and of itself to establish a seizure.
So I couldn't hear it on the audio.
And it does. I admit it's right after the loud audio of him saying 303. It is faint, but I can hear it. I understand reasonable minds differ on this subject.
At what point do you think you seized? I think your argument is Mr. Cyrus was seized some point prior to that.
Correct, yes. So I think that the order really cements the point, but yes, I would argue even before Officer Morgan had exited his car, Mr. Cyrus was seized based on the positioning of Morgan's car, the use of the spotlight and turning on overhead lights.
Do you agree the car was not, Mr. Cyrus's car was not completely blocked, that there was room for him to drive?
There was room for him to drive forward, but it's important to keep in mind if he drives forward, he's going to immediately encounter a dead end street and have to turn around and come back past Officer Morgan, who admitted he is parked in the middle of Ashby Avenue, I believe it is, which is also in the middle of that T intersection.
So what do you think the officer should have?
Offered less shows of authority. So in my opinion, he could have pulled up and parked behind Cyrus instead of in the middle of the street, not necessarily fixed a spotlight
Aren't you kind of
directly.
ignoring? I mean, this is, I think you might have something if this officer just drove up and was being snoopy. They had a call and I listened to that call and she said at least 2 times, suspicious activity. And you could just tell it was a sincere citizen. Isn't it true that if the cop did nothing or took it very lightly, that he's also not doing his job? I mean, he wasn't just driving by. He actually was looking for something that was apparently suspicious.
Yes, Your Honor, I agree that there's nothing inherently wrong with Officer Morgan being dispatched to investigate. I will reiterate that in the phone call, she says that the car is suspicious, but doesn't really testify why or.
Yeah, she gave some reasons why in the phone call. She said he was parked outside of somebody else's house. She noticed it and lights were off and he's sitting in the car. And then a little bit later, he's parked in front of her house. So that's kind of weird.
Unusual, maybe. I'm not sure I would characterize it as suspicious, but again, this is something I understand reasonable minds could disagree
Well,
about.
she did, and she's the caller.
Yes, Your Honor. But I think it's undisputed. There's nothing illegal reported. And so there wasn't reasonable suspicion or probable cause necessary to initiate a seizure.
Well, you said he could have shown less authority. I'm thinking of all the hundreds, if not thousands of video I've seen over my career of cop stops. And I can imagine a lot worse scenarios. I'm thinking of all the things that the movements I saw, the body language that I read. He had nonchalance, the word I use, when he walked around the car. And then when he did come up to his car, I think he put his left arm on the car and his right arm kind of on his elbow. That is not what we normally see when cops are trying to exert authority over someone.
To some extent, no, but I think parking in the middle of the street and exiting the car quickly by his own admission so Cyrus would stay where he was demonstrates that there was some amount of authority being shown here. And I understand there are worse or more authoritative, more coercive situations, certainly where it might be an even easier call that a seizure occurred. But that doesn't mean this isn't a seizure.
When the suspect is already stopped on the street, what's the additional injury or what is the constitutional concern, for example, spotlight? So we talk a lot about the spotlight. Why should it make a constitutional difference if the officer at night has on his headlights and then uses a spotlight? Why is that relevant?
Because the question, Your Honor, is whether under the totality of the circumstances, so considering all circumstances present at that time, including the spotlight, would a reasonable person in Mr. Cyrus's position feel free to leave? And the spotlight is particularly relevant in part to this question of whether it was possible for him to drive forward and drive away. His ability to drive is going to be impaired by it.
Wouldn't it make more sense to be worried about legal injuries, concrete injuries, deprivations of liberty, deprivations? So, for example, this woman who called in, rather than calling in, if she went out in the street and did the exact same thing this officer said, "What are you doing?" There's nothing wrong with it. It's perfectly legal for her to do that. So why does the police officer need more legal justification to do something that a normal citizen could have done?
Well, Your Honor, I disagree that everything Morgan did is something a normal citizen could done. A normal citizen cannot park their car and exit in the middle of the street. A normal citizen.
Well, let me put it this way. What violation of his rights would have occurred if this had been a citizen? What could he sue her for?
I mean,
And if it's nothing, then what's the legal harm?
because, so, I mean, false imprisonment is the only thing that comes to mind, but I realize that would be a large stretch. I'm not going to push that issue. But the Constitution gives heightened protection than even those sorts of things that give rise to civil claims. Any seizure whatsoever is unconstitutional if unsupported by reasonable suspicion or probable cause. There is no such thing as a de minimis seizure. And a seizure is defined again by whether a reasonable person in this position would feel free to disregard the police and leave.
On the issue of the spot, you said in Harlan, it's just a flashlight. It doesn't really advance this seizure notion. What to the argument, spotlight mounted to his car is pretty much the same thing as a flashlight.
So I disagree. It's pretty much the same thing. It's vastly brighter. It's
Fine. What if it's a really bright?
Yes, Your Honor. And again, I'm not necessarily arguing that the spotlight by itself initiates a seizure. It's part of the totality of the circumstances. And I think it is particularly relevant to this question, whether he could just drive away when he has I believe a several thousand lumen light shining directly in his face, and driving away would require at least carefully maneuvering around a squad car that's parked in the middle of the street, not to mention that has its overhead lights on.
If we find that the officer did not order him to stay in the car, does that weaken your argument for a seizure?
Weaken, I suppose, but I think there is still plenty to conclude that a seizure occurred here even without the order.
Did your client testify that he saw the top lights, the rear facing?
He did not, Your Honor. He didn't testify one way or the other, but I think that is something where a judge evaluating the totality of the circumstances like this makes a lot of common sense judgments. And it is common sense that lights projecting from the light bar on top of a squad car, even if they are pointing backwards, he's going to see that.
Can I ask you a different question related to common sense notion? If you have an encounter, a police citizen encounter that occurs at night, should we take into consideration safety practice? The officer says that I need the light to see inside the cabin, self-protection. That seems to ring true in this case. I have an offender who has a loaded handgun in the console. So is that a consideration for us that we should think about?
Your Honor, officer safety is certainly an important subject, but it can never trump constitutional protection.
How does he do that at night?
At minimum, I think park behind him, also not fix. I mean, you can see him adjusting the spotlight. He fixes it directly on Cyrus after he's looked in the cabin of the car.
But for safety reasons, he has to see in the cabin. So you're saying it's unconstitutional for him to try to see in the cabin at night?
Not in and of itself, no.
In fog, did we consider safety of the officer as a factor?
Oh, that particular question escapes me. If it may have been discussed, but I would like to discuss fog briefly because I think.
Well, how about officer safety? Let's stay with that. You'd
Absolutely.
agree that cases do discuss officer safety as a factor for us to consider under a Fourth Amendment Iowa Constitution, correct?
Yes.
And indeed, if the officer's safety is an issue, isn't also your client's safety an issue? I mean, isn't that the flip side? I mean, if there's going to be a gunfight, isn't that bad for both sides?
Sure.
So I'm just trying to see, going back to Justice McDonald's question. I mean, do you really think it's safe for officers to just pull up and in the dark walk up to your client?
It's already been tagged as suspicious.
As Chief Justice Christensen said.
Yeah, I mean, as safe as a private citizen walking up and having that conversation would be. I mean, I understand the importance of officer safety, but I think one, I will reiterate that can never trump constitutional protections. And this is an encounter that he initiated this encounter completely himself. There was a call, whether it needed to be investigated, reasonable minds could disagree about. But the point being,
So you're saying that it would have been reasonable just to ignore this call to the police department?
I think so. Nothing illegal was reported. I understand the calling citizen might have been upset.
Did it prevent something? We'll never know.
That's true. And to that point, The fact that eventually a firearm is discovered in the car is irrelevant to this analysis. What they found doesn't matter. What he might have been doing there doesn't matter.
I'm kind of interested in this officer safety idea, because if the officer was so concerned about safety, why didn't he just pull up behind, stay in the car and call in the license plate? Why does he get out of the car, walk all the way around and look at the back of the car in order to obtain a license?
That's an excellent question, Your Honor, and I don't have an answer for it. I don't mean to be flippant about officer safety. I understand it's very important, but I do believe this officer had other means to investigate this circumstance without initiating a seizure against Cyrus. If I could briefly speak to Fogg, I'm sorry, Your Honor. I would just point out that almost every circumstance that the court cited as not adding out to a seizure in Fogg is present here. There were no overhead lights in Fogg. The officer parked at least 20 feet away. There was no spotlight in Fogg, and I don't believe the officer admitted that he exited his car quickly so the suspect would stay in place as occurred here.
Am I correct? I can't remember the facts for sure, but in this case, not Fogg, in this case, weren't the lights the directional lights to tell people behind that might be coming up, hey, go to my left, go to my left? Isn't that different than the strobe lights and whatever cherries they have on top?
And Your Honor, my time has elapsed. Is it all right if I respond?
Of course,
to
it
your
was my question.
Yes, ma'am.
Yes.
So it was unclear. The officer said he could not recall if it was blue and red or amber lights. I would note that either of those is illegal for a private citizen to have. And I still think seeing a squad car with lights illuminated immediately when it pulls up and parks right next to one's vehicle would have an impact on whether a reasonable person would feel free to disregard the police and leave. Thank you. I'll return on rebuttal.
Thank you. Ms. Reinkoester?
Thank you. May it please the court, Mr. Irwin. There is no such thing as a per se seizure. The test is always a totality of the circumstances. And looking at the totality of the circumstances here, we can see that Officer Morgan made a reasonable decision to approach an unknown person in the dark to follow up on a call from a concerned citizen. In this case, he approached slowly, found the car he was looking for, used the spotlight to determine how many individuals he would be encountering, and then got out of the car and casually said, "Hey, how you doing tonight?" He did not quickly get out of the car and move towards the defendant. He did not issue any initial command.
Sorry, counsel, on that point, I understood his testimony at the hearing. He got out of his car, I thought quickly, so Cyrus would pick up, stay where he was.
I agree with that.
Doesn't that suggest that he was getting out quickly so Cyrus wouldn't leave? So he wouldn't?
So he testified he did that for officer safety purposes, but what's more important is how it objectively looked to the defendant under the circumstances. While Officer Morgan got out more quickly than he would have in a normal stop, when you watch the video, he is not moving quickly out of the car. That urgency is not being conveyed to the defendant under those circumstances. The defendant had no reason to believe that the officer was moving quickly towards him or wouldn't have done his normal preliminary, call in the license plate and put his body cam on before that. So I don't think that what his subjective reason in this particular case for why he moved more quickly matters. It only matters how the defendant perceived it.
Did he order him back into the?
I cannot tell that from the video myself, and I've watched it and listened to it. I can't even tell you how many times, but I don't think it's audible on the tape at all. So that is a disputed issue.
If we disagree with district court, that he did, what does that do to?
I think it makes it a much closer case, but
Enough that we should.
I don't think so in this circumstance. And that's partially because I agree that we don't know the tone in which that was conveyed. And when you do a survey of states who have, these various cases, just an order or a statement alone to please stay put, or can you just stay there, or something to that effect isn't necessarily enough to convert an encounter into a seizure.
Might not, and I don't. Your opposing counsel didn't get an issue, his second issue about the big black matter. But if we're going to talk about the tone of the officer, does that maybe matter?
Oh, I think the tone of the officer absolutely does.
I know, but if the tone of the officer matters, does the defendant's own characteristic of being a young black man?
No, because it is how an objective person perceives the tone of the officer. It isn't, there is no subjective quality to the analysis of how the person in the encounter perceives it. It's simply, is there an objective reason for how this officer conveyed a certain amount of authority? And while, that is a part of the analysis, is how an objectively reasonable person would perceive it. But the most important part of the analysis is, did the individual officer in this circumstance do something, show some amount of coercion, have a show of authority or force to the extent that any objectively reasonable person would believe they were not free to leave? And I don't think, we can see from the dash cam video that what Officer Morgan did in this case conveys that to an objectively reasonable person. And in terms of the spotlight.
So what if we, just looking at the emergency lights above his car, if someone is parked, a police cruiser comes behind with lights on, parks behind them, they can't leave, can't they?
No, and if his front facing reds and blues were flashing here, we would have a different analysis, but we don't.
Didn't he say that that it may have been his reds and blues simply rear facing, which if it's dark outside and those are going, the berries and cherries flashing, isn't it reasonable, I guess, to think that this driver may have?
It's possible, but I can say that from the dash cam video in this case, those lights are not visible at all. And I would also say that under the standard for these types of cases, which is that the defendant has the burden of proving that he was seized in the first place, that we have no evidence that this defendant did see them, which would then play into an objectively reasonable analysis. And he did testify at the motion to suppress hearing. His counsel could have asked him, did you see any reflection from the directional lights in back? What color were they? Or even when we go back to the spotlight question, was the spotlight in your eyes? Did you feel that that you couldn't drive away? Now, of course, his subjective response to that isn't, the crux of the analysis. It's how an objectively reasonable person would perceive that. But that information would allow us to view the entire circumstance under an objective analysis to make that determination. And because he did not elicit this information at the hearing, it's not established.
Can I ask you a fact question?
Sure.
At some point, the officer smelled marijuana. My understanding, recollection is he says immediately upon approaching. Do we know if that's before or after even initiated?
It's not clear from the record. My assumption has always been that it was when that part of the video where you see him actually go and speak to the defendant with his arm on the door is when he smelled it. But I don't think it is clear from the record if it is when he stepped out of his squad car or when he was moving, to get the license plate number, or if it was on his approach to the defendant. And in terms of, the use of a spotlight at night, converting, an otherwise, consensual encounter into a seizure, I want to direct the court to two cases. One was cited by the Court of Appeals in its opinion, State v. Baker, which is an Idaho opinion from the Idaho Supreme Court. And in that case, the Idaho Supreme Court said that they do not believe that an officer is constitutionally required to choose between a consensual encounter in the dark or turning on a spotlight and thereby effectuating a detention that may not be supported by reasonable suspicion. And we talked a little bit, you kind of mentioned officer safety plus defendant safety. And I think that is relevant because in this case, if the officer had maybe parked in back, not used any lights to illuminate, the car, the defendant may have been startled when somebody came up and knocked on his door, which creates a more dangerous situation for both people involved. So using the light illuminates the area. So both the defendant is aware that somebody's coming to speak to him and the officer can be aware of the circumstances with which he is approaching the encounter.
Do you think it makes a difference that the officer pulls up beside as opposed to being in back? Is that a necessity or is that one of the factors we have to?
I think it's one of the factors you have to think about. It was a decision he made in this case. From my reading of the record, I this is also not explicit, I will say that, but from my reading of the record and the way he talked about the road, how it was a hill that crested up, was that perhaps he parked there for protection. Because if he was going to be speaking to a driver who's on the side of a road and he's going to be standing on the side of a road, it's safer for both of them if the squad car is parked there with its directional lights, that no car can then come up over the hill, not see them in the dark, and maybe hit one of them.
Is it possible that the officer, as he's slowly going by, when Cyrus opens the car door into his path, that's why he stopped there?
It's possible. Yeah, he didn't come to a complete stop until the defendant, opened the door and reached. So he could have been moving his car to a different direction and decided, or sorry, different location and decided at that point to stop it.
So let me understand. I mean, the state's position is I'm parked legally and I'm in my car and an officer pulls up behind me, gets out of their car, starts walking around behind me, read my license. And I don't have to wait for them to read the plate. I can drive away.
Yes, absolutely.
Okay.
I mean, the cases recognize, I mean, since Mendenhall, since Terry, the cases have recognized that we live in a society where people are encouraged, that there is societal pressure to stay and talk to an officer. That absolutely exists.
I've said that, but
many times. I mean, that's it's what it is. And that's why the test requires that officer under that circumstance shows some show of authority to that individual above and beyond what our natural instinct is, based on how we've been taught to reply to an officer.
Counsel, isn't turning on your emergency lights and parking in the middle of this street and then training a spotlight on that person?
I disagree. And I have looked at a lot of the cases and I have found almost none that under the circumstances of a case similar to this, where a court has found a seizure. And that's where the other case I really wanted to direct this court to is a very recent case from the California Supreme Court called People v. and I'm going to say this name completely incorrectly, Tacardon, Tacardon. And the site is 521 P 3rd 563.
Yeah, so I read that case and I think some of us have. That case didn't have the overhead emergency light.
You didn't have the directional lights. So that, I mean, we really have to draw the distinction, because what matters here is what the defendant saw that would make him feel seized. If he never saw the directional lights, and if they were amber, then it wouldn't necessarily be more coercion on that part. And I think,
And isn't that the testimony where the district court made a credibility determination?
I think the district court only made the credibility determination on whether or not a command was issued to stay in the car. Because the officer himself wasn't.
It all happened in about 10 seconds, right?
Yeah, I mean,
The relevant part.
That's
Yeah.
correct. I mean, and I think Judge Greiner is absolutely correct there in his order when he says, we're parsing 10 seconds here, 10 seconds of activity to determine whether a seizure happened. And going back to Tacardon, if that's the right way to say it, they really draw a distinction for the spotlights and the amber lights, saying that, when we see blue and reds that coming up behind us, that's almost a universal. We all know what that means. But there are practical reasons for why someone might use a spotlight, and practical reasons why someone might use amber directional lights that do not have that same conveyance of authority. And, I think that, the analysis in that case is just, very relevant to the circumstances of this case. And you're never going to, well, maybe not never, but it's difficult to find cases that are exactly analogous, right? Because everything's just a little bit different. And that's why the test is amorphous. That's why the Supreme Court has always held it's imprecise for a reason, because we need to weigh each circumstance, the facts of each circumstance, whether it happened at night, whether it happened during the day, how many people were involved, to make that determination.
So if he wanted to seize him, he could have turned on the top lights that everybody knows means you're getting pulled over. Cyrus already stopped. And then he could have angled in to block. And neither of those facts present here.
Correct.
Something else I'm wondering, similar on that line, is if he was going to seize, in my experience, aren't people usually ordered out of the car?
That is true. Or it kind of depends, because, I've also seen, body cams or dash cam videos where when they have effectuated a seizure, in terms of a traffic stop, and they have a person who starts to get out of the car, almost universally, the officer jumps out of the car and starts yelling, "Stay in the car, stay in the car." It's a very clear order to remain.
Yes, but counsel, our question isn't what officer's motivation was. Officer wanted, right? It's what a reasonable person in Cyrus's position would have understood, right? So talking about what he was trying to do really isn't the primary point that we're aiming toward.
No, I agree. I am just sort of giving you a counterpoint for how it often happens when a seizure does occur. And, I think the use of the spotlight here, what you're talking about in terms of how it conveys to the defendant, the California case also says, it obviously alerts someone that they're an object of scrutiny. And that is good in both directions. But it doesn't necessarily convey, unless there are other circumstances present, that the person wasn't free to leave under the circumstances of that case. And I think, under the circumstances of this case, especially with Officer Morgan's testimony, that these are very common encounters. People get nervous when they see a car in their neighborhood that they're not familiar with. He goes out on these calls all the time. And he says most of the time, nobody is doing anything criminal. It's simply waiting for a ride or something else in the neighborhood. And that's why his approach here was casual. It was what it was because of the darkness and where they were in the road. And it wasn't meant at all to convey that the defendant wasn't free to leave under these circumstances. And I understand, I agree, we're weighing, not necessarily his motivations, but just objectively what he did under those circumstances and how they were perceived.
Is there any evidence that the defendant saw the rear facing directional light?
There is none, no. Mr. Irwin makes a point that it could have been visible based on it flashing off the trees or the houses in the area. That is possible. But the fact is we don't know that under the circumstances of this case. From the video that we have, we can't see them. So we know, at least looking forward, they're not visible to the defendant, and the defendant didn't testify that he saw them in this case. And so since it's his burden, I think that, that cuts against him here. So for all these reasons, the state would ask that you affirm Mr. Cyrus's conviction. Thank you.
Thank you. Mr. Irwin?
Thank you, Your Honor. So I definitely agree it does not matter what Officer Morgan was trying to do. It matters how a reasonable person in Cyrus's position would feel. However, I think it is highly significant that Morgan admitted, there's issues with the transcripts, but I believe it's clear that he admitted under normal circumstances, if a person has their door open, he would order them to stay in the car. He never definitively testified he did not give that order here. He just said he could not recall what was said. I think that combined with his testimony that he would normally order a person to remain in the car.
But Mr. Irwin, Mr. Reinkoester has a good point that watching the video, it does appear pretty casual. He seems kind of like, could be just, walking, making a tour of the neighborhood or something. It's very casual pace it's going in. It doesn't, we can't hear, but it doesn't look like it's giving it.
Well, again, respectfully, I disagree. He acknowledged that he said something. He acknowledged that he would normally order the person to stay in the car. He acknowledged that he got out of the car quickly. That's why we don't have body.
He said he actually, in this situation, he doesn't think he would have told him to stay in the car because in his mind, he was not trying to create a seizure because he knew that he didn't have suspicion of probable cause.
Yes, Your Honor. He, in my view, gave squarely contradictory testimony on that point. He did testify that he was trying to keep things casual. He also testified if someone's door is open, he would normally order them to remain in place. And most importantly, he did not definitively say, I am positive I did not give that order.
Yeah, but now we're back to the credibility finding. This is the topic the judge said he found the officer more credible and your client not credible.
But credible as to what? I'm not sure I gave that.
Whether or not he was ordered to get back in the car. Isn't that where it was? His foot coming in and out?
Yes. So the judge did find that Mr. Cyrus's testimony was not credible due to a juvenile theft conviction. But again, I think
Wasn't the only reason, was it? Wasn't it? And the juvenile conviction, wasn't it?
from my recollection, that was the only reason given for not finding him credible. I could be mistaken, but from what I recall, that was the only thing the judge said.
Well, no, lack of corroboration on the video. Some of us at our age couldn't hear.
Well,
And-
yes.
And there weren't there several, there were at least 2 juvenile convictions. Dishonesty, right?
Correct. Yeah, I didn't mean to minimize that. I believe it was a burglary conviction and a theft conviction. Yes. Your Honor.
Would it matter if, assume he did say stay in the car? Is there a constitutional difference between that and saying you can't leave? Test is whether he's free to leave. I'm not sure that saying stay in your car necessarily the same.
It's not identical language, but I think it conveys the same message, and I think it would have the same impact on an objective, reasonable.
Once again, we're looking at tone. Isn't it in response to him asking? Did he say, can I get out or something? Did he testify? He asked if he could get out?
Yes, Your Honor.
That's what I
sorry.
thought. So then doesn't it matter if the cop said, get back in the car? Or if he said, you can stay in your car. I'd rather sit in my car than stand on the road. To me, thank you. I would appreciate that.
Of course it matters, but under these circumstances, telling Cyrus to stay where he was is a completely invalid order. If he was genuinely free to leave, the officer has no business
But
telling
if he
him to
asked
stay.
permission, if he was just being your client said, can I get out of my car? Isn't maybe saying, no, you can stay in your car. Isn't that also implying it's up to you? You can stay in your car.
It would be if that's what was said. I do not believe that's at all what was said. I'm very short on time. I would like to discuss the racial component, Your Honor. Sorry. So I just want to point out, considering that a person is a young Black male is not a subjective test. It is an objective fact that Cyrus is a young Black male. The question is not how he personally felt, but the question is, as it always is in totality of the circumstances questions, I was thinking about it. It's always kind of informed speculation when judges make these calls. They're thinking about what a reasonable person should feel. And if there is reason to believe Cyrus's age, minority status, anything else would have affected his viewpoint on whether he was free to disregard the officer and leave in this situation, that should be taken into consideration. I think.
And does our test go from a reasonable person? Do we break it down to age, gender, race, etc. every time? And how does the cop factor that in at night?
And Your Honor, my time has expired. May I respond? So I agree. I understand it could splinter into that. I think that anything like that would be considered if there's reason to believe it would be relevant. I'm not saying any of these things would be dispositive or that a judge has to find them relevant. If the judge finds, no, it doesn't matter, that's fine too. But the test is a totality of the circumstances.
So I take it then your argument, in some cases, the race would matter as to whether or not we find a seizure.
Yes.
In some cases, then rules of evidence would be affected. That's what we're talking about. This is an evidentiary issue, right? It's a suppression motion.
Well, it's a constitutional issue. I'm not.
But no, this case is an evidentiary issue about suppressing evidence, correct?
Correct, Your Honor.
So it's your argument that the rules of evidence remedy here, whether we suppress this, depends on the race of the.
My argument is it can. My argument generally is courts are not forbidden from considering circumstances like that. And I think there's a trouble and widespread opinion that they are, including by the judge in this case. It goes back to Mendenhall. Mendenhall specifically mentioned things like these as being not irrelevant in the analysis.
Doesn't that create an equal protection problem for us? Let's assume this exact same fact. And if you think race makes a difference, I think you argue in your brief it does. If this were a white defendant, the evidence would not be suppressed. If it were a Black defendant, how is that not an equal protection problem? Or to apply a rule of evidence differently depending on the race of the defendant?
So I'm not necessarily saying that the race question would be dispositive. It could have an impact. It could have an impact the other way. A judge might find a particular group is more likely to feel free to leave than any other. I'm simply saying it should not be ignored. There is no law that says it has to be, and Mendenhall, in fact, says it should be considered. Thank you, Your Honors.
Thank you. Case of State of Iowa versus Cyrus is hereby submitted.